Hello, my name is Michael Tesoro, and I prepared this presentation entitled ACCC Essentials, Understanding the ACCC's 2022-23 Compliance and Enforcement Priorities. And this presentation is based on an article which I recently uploaded to LinkedIn, which goes through these issues in a lot more detail. So I direct you to having a look at that particular article if you want a bit more in-depth detail. So I guess the first thing, I use that image of superheroes because I've got a very high opinion of the ACCC's abilities and the way they've been really punching above their weight in recent times with some really cutting edge, world leading cases, particularly in the digital area, and cases like Trivago and Viagogo. And just the width of their mandate is just remarkable. I don't think there's any regulator in the world that deals with so many key issues and does it so well. So I think they're entitled to that status of the superheroes of the regulatory scene. A bit of background about myself. I'm a competition and consumer lawyer. I've been working in my own business, Salery Consulting, for 13 years, and I specialise in competition consumer work, do a lot of compliance as well. Prior to that, I worked at the ACCC for 15 years, and I had a variety of roles. I was Director of Enforcement, so in that role I had a team. We ran about 600 investigations, so pretty aware of how to prioritise matters through that job, but also was the Director in charge of the Sydney Mergers and Asset Sales branch for a few years, and also did shorter stints in GST and heading up the ACCC's waterfront team. So the outline of the presentation, I'll start with a bit of background, then go and discuss why the ACCC has priorities, and then how it goes about prioritising its work, which is quite a sophisticated approach. Then I'll look at what the 2022-2023 priorities are, which I like to describe as the hit list. So I'll go through the hit list for this year, and then discuss the enduring priorities. A couple other issues that Rod mentioned when he released the priorities, which are of interest, and then final commentary about the priorities. The question is, why is it important for the ACCC priorities to be front of mind for business? And the clear reason is that the ACCC is a very interventionist, effective and aggressive regulator. And if you don't know what they're up to, then you've got a risk of getting caught by them and fined a lot of money. Realistically, the penalties they've been obtaining through the courts have been rising exponentially in recent years, with in the last couple of years them obtaining 200 million plus penalties against two corporations. So they received $125 million against Volkswagen, and also a penalty against AIPE, which is one of the vocational education training providers, of 153 million. So they're getting very large penalties, and I just can't see that changing. In actual fact, it's highly likely the next few years there'll be regular 100 million plus penalties awarded against companies for both competition and consumer law breaches. The other reason it's important to be on top of the ACCC's priorities is because it has a formidable reputation amongst the general public in Australia as being an active and effective regulator. So consumers know the ACCC's name, and I think they respect the fact that it has a strong enforcement reputation. So any business that's taken to court by the ACCC is generally judged very harshly by the Australian public. The media will generally weigh in pretty hard against companies that get taken to court by the ACCC. So the risk is, if you get taken on by the ACCC, your business is likely to suffer long-lasting and significant reputational and brand damage. So anything you can do to try and avoid that type of attention is a very good investment. So the way that the priorities come about has changed over the years. They were first announced in 2012, but since then the process has become more sophisticated, with the ACCC consulting various stakeholders, consumers, lawyers, businesses, to find out what should be on the priority list. So they do that towards the end of the year. They formulate them and then they release them in February or early March for the following 12 months. And they're released at this conference, the CEDA conference, every year. And the key thing about these particular priorities is that the ACCC is very focused on reporting in its annual reports about how it's going meeting these priorities. So in the annual report, they'll have lists of the cases they've taken, and they'll actually measure whether those cases fall within one of the priority areas they've identified. So there's a strict reporting aspect to it. Now, one recent change they've made in relation to the priorities this year is they've changed the reporting period. Usually they'd been from February to February, which didn't make a lot of sense because the ACCC's reporting period for Parliament in the annual report is from the traditional financial year, which is July to June. So what they've decided to do here, which seems to be quite overdue really, is they have decided to move the timing of the priorities to align with their annual report. So these particular priorities will be in place for longer than usual. They'll be in place largely for 18 months, which means they'll be in place from February 2022 through to June 2023. And then after that period, they'll be releasing them around the time of their annual report. Annual reporting period starts, and then they'll be tracked over that 12-month period. So that's an innovation which I think is overdue. Now, why does the ACCC have priorities? Well, there's a few reasons. I think the first reason is it's a good mechanism to prove that you're transparent about what you're doing as a regulator. It's important for businesses and for consumers to know what the ACCC is looking at and the reasons why it's looking at those areas. Obviously, government likes to know what regulators are spending their money on. And it's an accountability mechanism as well, because the ACCC not only says what it's going to do, but then it proves that it's actually done what it said it was going to do. So there's a high level of accountability. But the other big reason why the ACCC needs priorities is because it gets so many complaints and it can't do them all. So I think in the last financial year they received over 396,000 calls, a large proportion of which were complaints. So they have to have some mechanism to reduce the number of complaints, identify the ones that are important, and to pursue those. So this diagram in the last annual report called the litigation funnel, which explains how they assess matters and then cull them down to a manageable number. So as you can see, out of all the complaints they receive, they'll conduct initial assessments in 254 matters, and that'll involve allocating the case to an investigator who'll do a bit of research, check out if there's other complaints about the company, whether they had previous breaches of the law, and make an assessment of whether the matter should go further. Of those 254, 157 make it to the initial investigation phase, which is when the ACCC will write to the company complained about and ask them to explain their conduct, but also ask them for a lot of information and documents about the way they're operating. Then that'll be culled down even further to 68 matters where they'll conduct an in-depth investigation. And that's the stage where the ACCC is getting serious about the case. It'll be reported to the commissioners on the enforcement committee and explained to them, and the commissioners will make a decision whether the case should continue or whether it should be dropped at that stage. If they decide it's to be continued, they'll often approve various investigatory steps. So they may approve the issuing of 155 notices or the conduct of a search warrant. And often they will allocate a budget to this case. So they'll allocate a large amount of money usually to pursuing the case in terms of retaining a law firm to assist in the preparation of statements or preparing a statement of claim or the retention of an expert to give evidence. So a financial commitment will be made at that stage. And as you can see, of the 68 cases that hit the in-depth investigation phase last year, 15 ended in litigation. But that doesn't tell the full story, because ACCC resolves cases in a number of different ways. The other two ways being to enter into a Section 87B undertaking, and in the last financial year there were 14 of those, and the other way is the issuing of infringement notices. So in the last financial year they issued infringement notices to 20 companies. So when you add those three numbers up, you end up with 49 outcomes. So as you can see, out of those 68 cases which hit the in-depth investigation stage, 49 of them resulted in a formal resolution or litigation, which is a very high strike rate when you think about it. That's 70% of the cases that hit in-depth investigation result in some formal outcome. So if you're a business and you're at that in-depth investigation phase, you've got to take it very seriously, because there's a high probability that you will either be sued, be required to enter into 87B undertaking, or be fined through an infringement notice. Now, how does the ACCC approach its prioritisation? It doesn't simply identify a number of industries and decide to pursue every case in that area. Rather, what it looks at is its objects under the legislation, which is the Competition and Consumer Act and the Australian Consumer Law, and it looks at three things: the goal of promoting competition amongst businesses, also promoting fair trading by businesses, and protecting consumers in their dealings with business. So as you can see, it's very much focused on the detriment of loss of competition, companies not trading fairly with consumers or with other businesses, and also protecting consumers from being misled, being ripped off. So the detriment issue is a very major consideration in deciding to pursue any cases. Then they provide some further guidance for the types of matters that they will weigh up when deciding whether to pursue a case. Clearly, matters of significant public interest or concern will be high priority. They could be matters that are in the media or being talked about a lot by consumers. For example, the complaints during COVID about not being able to get refunds for travel expenditures made to airlines, for example. So any matters that's of public concern is going to be more likely to be pursued by the ACCC. Then they look at substantial consumer or small business detriment. So obviously detriment to those two groups will add importance to pursuing the case. If there's detriment to a big business, the ACCC won't be very interested usually. They'll often encourage big businesses to take their own private action. Then they look at national conduct by large traders, and they understand this as being important for two reasons. Firstly, the level of detriment caused by conduct by a large national trader is going to be greater than, say, a more localised trader, but also they see the benefits of taking these type of matters in terms of achieving general deterrence. The theory is that if you take action against a large national player and you punish them for breaking the law, other traders in the same industry who may be smaller, who may be engaging in the same conduct, will see that message and decide to change their own practices to comply with the law. Then they're often looking at matters which involve significant new or emerging market issues. Often that involves technology, new technologies that are being brought in to challenge incumbents. Clearly the focus of a lot of enforcement work at the ACCC recently has been on digital platforms. The final thing is where an action is necessary to clarify aspects of the law, and that's really important. For example, the Quantum case where the primary judge messed up the judgment and then the ACCC appealed that to a federal court headed up by Justice Alsop, and he was able to the court was able to fix up the problems with that initial decision. I think one thing that's interesting is that the ACCC is rarely likely to take a case that purely involves a theoretical legal issue. Often they'll take a case which involves detriment to consumers or businesses, and there may be also a need to clarify an aspect of the law. And the areas that I think they've been sort of seeking to clarify the boundaries of the law have been primarily unconscionable conduct, and also the scope of consumer guarantees. So they're the two areas that there's been a lot of attempts to clarify where the law ends. Now, what are the 2022-23 priorities? Well, the hit list starts off with environmental claims on sustainability, and this is a priority which has been in the ACCC's priorities in the past, so it makes a pretty welcome return to the list. And in his speech, Rod Sims explained that this is back in the priority list, mainly due to the fact that the ACCC in recent times has been hearing growing concerns that there are some businesses who are falsely promoting the environmental or green credentials of their products and services. And the ACCC sees this as a crucial issue, both in consumer terms and competition terms. So in consumer terms, there's obviously a big price premium to be paid by consumers for products that are genuinely environmentally friendly or benign, and consumers are willing to spend a bit extra on those type of things. But secondly, there's a competition element that companies who are doing the right thing, making sure their claims are valid and investing in technologies to provide more environmentally sustainable products, are losing sales to other companies that are making false claims about their own credentials, environmental credentials. So it's important to balance up the field so that companies that are doing the right thing don't lose sales to companies doing the wrong thing. The next item is not a surprise, it's the digital economy, but the focus here is on manipulative or deceptive advertising and marketing practices. And this is a really interesting area which focuses on the idea of dark patterns. And the ACCC is very concerned that there seem to be a growing number of what they call manipulative techniques to exploit or pressure consumers into making the wrong purchasing decisions. The dark patterns have been defined as a way a user interface is designed using choice architecture to trick or nudge consumers to do things which they don't really want to do if they thought about it, or are not really rational responses. And I think the classic example is when you're seeking to download a competing program on your computer and you get a warning saying that it's unsafe, you're taking a chance. It's obviously trying to scare you into reversing your decision, cancelling the download and going back to default product. So that's the kind of things that are being looked at, and really this choice architecture that results in these dark patterns is heavily reliant on the observations made by behavioural economics. So the fact that we have bounded rationality, that we really can't process all the information that's available to us to make a rational decision, that we have a range of cognitive biases, that we tend to have a status quo bias. So all these different factors are playing a part in the way that digital platforms design their various platforms and applications. Now, Rod Sims in his speech gave a few examples of dark patterns. He referred to low stock warnings, which aren't true, false sales countdown timers, talking about targeting advertising, which seeks to use consumers' own data to exploit their individual characteristics, pre-selected add-ons, design interfaces that discourage unsubscribing, and I think we all know the feeling of how hard it is to unsubscribe, manipulating online reviews and search results, and so on. So he's identified a range of dark patterns which he thinks are problematic. And then he refers to the Trivago case as an example of a dark pattern case, but I don't think this is really correct, because Trivago involved a misleading representation by Trivago to its users that the accommodation providers which were coming up at the top of their list in response to their search terms were actually the most suited to those search terms. But the reality was that those accommodation providers were being boosted in their rank because they were paying Trivago a higher payment fee, a higher cost per click to get in a better position. So that doesn't sound to me like a dark pattern. I think the better example of dark patterns is some of the conduct that Viagogo was found to have engaged in, particularly the way it was conveying representation on its website that the number of tickets available for a particular event were quite limited and scarce. And that wasn't true. It was effectively describing the number of tickets which it had available to consumers, but not the total number of tickets that were available for the event as held by other ticketing agencies. So what they were doing there was creating this scarcity concern. And so the whole idea of creating this false impression of scarcity is a classic example of what's called the scarcity heuristic in behavioral economics. So I think that's a better example of a dark pattern. The third priority there is obviously COVID-19. There's a lot less activity there, but it's something that still needs to be looked at. Clearly looking at the way that events and travel has been, cancellations are being processed, how credit vouchers that have been given to various consumers are going to be honoured, but also ensuring there's no price gouging in relation to rat tests. I think that's probably declined a bit. They seem to be very available at the moment, but that's something that the ACCC is going to keep monitoring very closely. The next three priorities are here. The first one is pricing and selling concerns in essential services, focusing on energy and telecommunications. This has been on the list for ages, and I think there's continuing problems in these two sectors. A number of years ago, the ACCC took very aggressive enforcement action against a number of energy companies, AGL, Origin and Energy Australia, for their door-to-door selling activities. And I think they largely stamped out the more egregious conduct that was occurring in that sector. But unfortunately, there's still a lot of bad conduct occurring, mis-selling of energy products and misleading representations, and the same with telecommunications. So just wondering at some stage whether this is going to become a enduring priority, because it just doesn't seem to go away. The next category is in relation to consumer guarantees, primarily for motor vehicles, but also caravans. And this is another priority which has sort of changed over the years. A few years ago, this priority was consumer guarantees in relation to both car manufacturers, but also appliance manufacturers. And the appliance manufacturers have fallen off this priority list, I think largely due to the fact they got the message that their products were subject to consumer guarantees, that they had to offer people a replacement product if the product was not of acceptable quality, and therefore they got dropped off the list. The group that hasn't got the message is motor vehicle manufacturers, who have this strong culture of repairing cars no matter how bad the problems are with the vehicle. There are examples in that Mazda case with cars that have had 3 engine replacements and the manufacturer still wants to repair those vehicles. So I think the ACCC is getting pretty sick of this conduct and it's made it a priority again. But I think this coming year there's going to be a lot of enforcement action. The tribunals all around the country, the consumer tribunals, are actually absolutely clogged with claims against car manufacturers for this very issue. So I think there's going to be a lot of enforcement action, some big penalties, and the ACCC is also pushing for changes to the law to make a breach of a consumer guarantee a penalty provision. The final issue there is competition and consumer issues relating to digital platforms, and this is a reference, I think, largely to the recent discussion paper which the ACCC put out, which outlines a range of options to try and curb the substantial degree of market power which digital platforms have. And the premise that the discussion paper has is that the powers which the ACCC has at the moment to curb this incredible degree of market power that these companies have is not adequate. They need new tools to be able to effectively deal with all the problems created by the digital platforms. And the options they've outlined in the discussion paper include codes of conduct, rulemaking powers. Also, they even talk about an access type regime. So they're putting a wide range of options on the table, seeking stakeholder feedback. They'll prepare some recommendations and go to the government, whoever that may be, in September 2022 and see if the government will give them some additional powers to try and curb what they see as the abuses being undertaken and committed by the digital platforms. So the first of the next priorities is global and domestic supply chains. And I think anybody who's been involved in importing goods in the last 12 months is aware of just how much global shipping rates have increased for, say, a 40-foot container. I think you've seen price rises of 7 times in the last 12 months. And there's also massive timing problems with delays. And so the question is, what has caused this? And I've heard so many different explanations for the delays and the increased timing. I've heard explanations that there's been this mismatch of empty containers that all end up in Australia because we're more of an importer than export, and that's created some problems apparently. I've also heard that there's been Chinese energy shortages, which has led to problems in pricing, and also the COVID pandemic. But the main thing is that the regulators are a bit suspicious about the reasons the prices have gone up, and they've decided to get together in a group, the Five Eyes group, and investigate the reasons for these price increases. So Australia has got together with a number of overseas regulators to really look at this area and see if there's any untoward conduct occurring, primarily collusion. And I guess it's fair to say that the shipping industry does not have a very good reputation with collusion. The recent penalties against many of the major shipping companies for a long-term hardcore cartel in roll-on, roll-off cargo indicates that these companies are not reluctant to necessarily enter into cartel arrangements, and so that's going to be really interesting to see how that plays out in the future. The next area is the financial services sector, particularly with payment services. And in the speech, the ACCC mentions debanking, digital currency and cross-border payments. And the concern the ACCC has is that incumbents may be seeking to prevent these new payment methods gaining a foothold in the market. So they're going to be very active in monitoring this. And in the speech, Rod Sims mentions the Visa case in 2021, where the ACCC, in my view, quite surprisingly accepted a court enforceable undertaking against Visa for allegedly limiting competition in relation to debit card acceptance through large merchants. And I think by referring to this case, the ACCC is making it clear to financial service providers that if there are efforts to prevent entry from payment methods and trying to impede card acceptance, they'll be taking a different approach in the future. They'll be taking litigated outcomes and be seeking large penalties. So it's a sort of a warning shot across the bows of a lot of financial institutions. The other organisation or company which gets mentioned in this context is Apple, which is mentioned as having concerns about the way that it's restricting third-party access to its near-field communications technology and also impeding the use of competing payment methods on its Apple Store. So these are the kinds of issues that the ACCC wants to look at very closely. The next priority isn't very well explained in the paper. It refers to exclusive arrangement by firms with market power. And the case they refer to is Peter's ice cream case, where there was exclusive dealing arrangements. So I'm not too sure what they're going to be looking at, but I can't help thinking that this is another reference to digital platforms and the types of exclusive arrangements that they habitually entered into with different suppliers and customer groups. So I think that digital platforms will be the focus of this particular priority as well. The next three priorities, the first one is ensuring that small businesses get the benefits of particular codes. And the two areas they've identified is agriculture and franchising. In agriculture, there are two codes which are relevant, the horticulture code and the dairy code. And clearly the focus there has to be that the disclosure requirements under those codes are being met by larger players, that the inequality of bargaining power is being addressed, and so that these small businesses get the benefit of the protections in those two codes. Franchising is another area where it seems to always be on the priority list, and it's probably an area where I think the ACCC has done less enforcement, but I think that might pick up in the coming 18 months, largely due to the fact that the penalties for breaching the franchising code have risen astronomically. So I think the ACCC is likely to be much more active in that sector. The next one is ensuring that the compliance with the button battery safety standard is occurring. So the ACCC brought in this new standard, was very innovative in seeking to push this standard out there. Companies are now aware of the obligations to comply with this standard, and so if there are companies in the market that aren't complying, there will be litigation. There's no doubt the ACCC will take litigation against any company that's breaching this code. Then the final category in the priorities is very interesting. It's consumer product safety in relation to young children. And it seems to me sort of a broad priority where the ACCC will be going into the market, trying to identify products which may cause danger towards young children and seek to address those problems. And it might be that they identify another area like button batteries and say we need a new standard, or they might be just looking at specific products which they believe are unsafe. But the interesting focus here is on compliance, enforcement and education. So obviously they're going to be looking at setting some standards for industry to follow. They're going to be seeking to educate the industry on those standards, and then if those standards aren't met, there'll be enforcement action. So that's an interesting priority, and it'd be interesting how it pans out in practice. Then there's the enduring priorities, and the first enduring priority is cartel conduct, and that applies to both civil and criminal cartel conduct. And clearly the recent events in relation to cartels has caused a lot of reflection, I think, at the ACCC. They have been unsuccessful in the country care case, where the case went to a jury and both the corporate and individual respondents were acquitted in a very short period of time, and then the debacle that was the banking cartel case, where the DPP was unable to get a valid indictment up, despite trying for 3 years and despite being given a lot of good free legal advice by the judge. So there's some real problems there, and I think the real focus has to be on trying to explore the reasons for the recent case failures and making sure that they've got the sufficient training and expertise to run criminal cartel investigations. The ACCC has announced an internal review to try and get to the bottom of what may have gone wrong, but realistically you've got to maybe have an external review and find somebody who's run these cases and been successful, which means you're probably looking at somebody outside Australia, because nobody in Australia has run a successful cartel prosecution that's been contested. And so I'd be looking to the US, somebody maybe formerly from the Antitrust Division of the Department of Justice, a person like Scott Hammond, who was a high-profile officer of the Antitrust Division. He's now in private practice. Somebody like that, bring them in, get them to do a review, an external review. They've had a mix of success, but you've had 3 big shipping companies pleading out to criminal charges, but realistically they've been prosecuted overseas and they had no defence. You've had a small Forex trading entity which is being criminally prosecuted, where everybody's pleaded guilty, the company and I think 5 individuals, and that was a very small business in the Vietnamese community. And then you've had the alkaloid case where they also, the company and the individual, pleaded guilty. So you've got these situations where a number of people are pleading guilty without a contested hearing, and then you've got 2 cases where there's a contested hearing and the ACCC has gone down. So that doesn't augur well for the future of criminal cartel investigation and prosecution in Australia. The next category is looking at anti-competitive conduct, and this is always a priority for the ACCC, and particularly looking at Section 45 agreements, which is agreements which may substantially lessen competition, usually between big parties. The big case recently is the New South Wales Ports case, which is now on appeal, and also looking at a new misuse of market power case. They settled the case against Tasports, but they'd be keen to take another case and have it run through the courts and maybe get some important case law. The other areas of enduring priorities are product safety, so that's obviously a very important area, and what you're going to see there is probably a broadening of ACCC activities, because the Takata recall is effectively over with a 99.9% replacement rate, and that was using a lot of resources at the ACCC. A lot of people were involved, but now they're sort of freed up to get into new areas, and I think we can expect the ACCC to continue its proactive role in seeking to identify hazards and to try to initiate new standards, and also pushing very hard for a general safety standard in the next 18 months. Obviously, the ACCC will be seeking to continue its work in helping vulnerable, disadvantaged people, and it had a wide range of cases that ticked this particular box in the last few years, involving the vocational education and training providers who had really targeted a lot of vulnerable and disadvantaged consumers. And so they ran many cases in that area, and whilst they didn't get a red nickel back from any of these providers in terms of penalty, because they all went to liquidation, the ACCC was instrumental in getting the Commonwealth Government to write off all the debts that these vulnerable, disadvantaged consumers had incurred by being misled by the VET providers. So it was a very good outcome, and ACCC did very well in helping these consumers. The other area where the ACCC has done a lot of work under ROD is with Indigenous Australians. Unfortunately, there are a lot of groups that go and take advantage of Indigenous Australians, particularly in remote communities, and the ACCC has done an excellent job highlighting the work that they've done in terms of education and providing new resources for Indigenous Australians. But the actual pinnacle of the whole activity has been the recent case against Telstra, where they admitted engaging in conscionable conduct and were fined $50 million. So I'm quite sure that the strong role that the ACCC plays in trying to protect Indigenous Australians from very dishonest conduct will continue in the future. So another couple of issues that the ACCC chairman mentioned in his speech was infrastructure and mergers. And infrastructure, he mentioned 4 areas. The NBN, which it's fairly uncontroversial, but given the status of the NBN at the moment, the issue is what is going to be the appropriate regulatory framework for NBN going forward. And that's a process of consulting with stakeholders, working out an appropriate regulatory framework and putting that in place. But the other area he was interested in and concerned about was regional telecommunications. He made some reference to proposals by some of the big telecommunication providers to work in regional areas together, and that caused some concern because it's quite a concentrated market. And so I think he's highlighting a need for the ACCC to really be vigilant in that regional telecommunications market to make sure there's no anti-competitive conduct occurring. Also, an area to be monitored very closely is the way that the players in the market engage with each other. Clearly, Rex has been making a lot of allegations about Qantas engaging in predatory conduct, putting on new routes, putting extra capacity on and things like that. Nothing's ever been established, but it's clearly an airline is a very tough market, and you've got to keep your eye on to make sure that the dominant player doesn't take advantage of its market power to damage its competitor. And I guess Virgin, having gone into administration and come back out again, indicates just how tough that market is. Airports has been a constant source of concern for Rod Sims, who's often horrified by the way that the airports have been given so much power to set high prices and to reap very high returns for a lot of their services. I don't quite know what the solution is there. I think that's probably done and dusted in terms of anything that could happen, but something that the ACCC is going to keep monitoring on and letting the public know just how much power the airports have. The final issue was insurance monitoring, which again, there's some market failures happening in that industry, and that might be an industry where the government is forced to intervene to try and get some proper market outcomes that aren't being produced at the moment. The final issue you sort of mentioned was mergers and talking about merger reform, and it's Rod Sims's strong view that the current laws are not fit for purpose. They're a voluntary scheme that isn't suspensory. People are gaming the system, ignoring the ACCC, providing limited information, withholding information. So he's effectively saying the system is broken, it needs to be changed. It needs to become a mandatory system that suspends the merger pending ACCC approval. The other thing he wants is specific rules in relation to digital platforms. And the reason specific rules are needed, in his view, is because current merger laws are not able to deal with the issue of killer acquisitions, which is effectively a digital platform buying out a small, innovative company that's just starting out and buying them when they're a nascent competitor before they've been able to achieve a scale that could bring a real competitive dynamic to the market. So he's saying that the current laws don't give the ACCC and other regulators around the world the powers they need to stop those particular types of mergers. So he's suggesting a wide range of reforms to merger laws, specifically directed at digital platforms, including reverse onus of proof, different tests to focus rather on the entrenchment of existing market power rather than substantialist in competition. Also looking at changing the legal tests. There's even reference in there to a outright prohibition on particular mergers in the digital sector, which ticks certain boxes. So it's a very controversial proposal. So these ideas have all been thrown out there, and it's going to be really interesting to see whether, firstly, the new chair of the ACCC has quite the same enthusiasm and appetite for these changes, and also whether the government is interested in pursuing these ideas. So if you're a business and you're listening to this and you've got a compliance program, that's great, but it's important to update it regularly, particularly letting your staff know what the compliance priorities for the ACCC are in the coming year. So include that in your annual training sessions. If you don't have a compliance program, you really should set one up. It's really an essential thing. And so there's just a bit of a guide there as to what you should have in it. I always think it's good to start with the risk assessment, work out where you've got problems in your business, and then go through the process of appointing a compliance officer, setting up the relevant policies, clearly compliance policy, complaints handling, whistleblower. Then you've got to make sure you've got an effective complaints handling procedure so you can identify complaints, work out where your problems are and deal with those problem areas. And then finally, some regular competition and consumer law compliance training where you tell your staff about the compliance policy, but you also tell them a lot about the priorities of the ACCC. So that's a real must. I think it's a priority to set up a compliance program if you don't have one already. So just finally, it's obviously Rod Sims's final act, I guess, as the chair to issue these priorities going forward. And he's achieved a huge amount of stuff in his 11 years. I think he's really brought the ACCC into a new arena of being very effective in terms of its outcomes, but also very well run. It seems to be clear in what it's trying to do. It's achieving what it's saying it's intending to do. It's been run very well. So I think that's a real improvement in the way the ACCC operates. And I think his real top priority in my view is the introduction of these compliance enforcement priorities, because it's just a real innovation. It's made the ACCC much more transparent and accountable. But you see all these other regulators copying that same approach since he introduced it in 2012. Digital platforms work has been sensational. It's been world-leading stuff. The ACCC has done a remarkable job in investigating these markets, understanding these markets, explaining how these markets work, and then coming up with some workable ideas on how to fix the problems. They haven't rushed into solutions. They've really been very thoughtful about how to really solve these issues. Law reform, there's been plenty through Harper, new section 46. There's been the class exemptions, also the very significant unfair contract term laws, which are soon to be toughened up. So he's done a remarkable lot of work in law reform. As I said, great work in Indigenous communities. It's been a highlight for me in terms of just so many different initiatives there. And I think changing the role of the ACCC from being a bit of a follower in product safety to a real leader in the field globally. So he's done a great job, and I thank Rod for all his hard work. So that's all I had. One thing I probably should mention is that I have a YouTube site, and there's quite a lot of videos on that site which deal with different issues. So in this talk, I mentioned compliance programs, and so there's a YouTube video there which goes through how to set up a compliance program. There's a lot more detail in another video about the banking cartel. There's another video that talks about the ACCC's discussion paper in relation to digital platforms. So if there's any issues that you found interesting in this talk and you wanted to delve a bit deeper into them, have a look at the YouTube video channel. There might be something there that answers those questions that you may have. And if you still have any questions after that, feel free to give me a call or drop me an email. Bye-bye.